Law Talk with Nick Maruchak. Thanks to MKI Legal, your trusted employment and family lawyers.
I fought the law and the law won. I fought the law and the law won.
Let's officially bring Nick Maruchak from MKI Legal to the microphone. Good morning, Nick.
Good morning, Bowie.
Good to see you. A couple of topics we covered last week. One of them, comes from one of our producers. We'll call him Mr. X. His real name is Sean Lindsay. He reckons people that Google are listening and Facebook are listening to us over our phones. Is that right?
Well, I have researched this, and I don't think they're doing this. So here's a few reasons. First of all, the allegation is that when your phone is turned off, Facebook or social media platforms are secretly recording your conversation, and then all of a sudden you see an ad for something, and that's where it came from, right? They're listening. So first of all, Facebook have adamantly denied they are not recording you, and they're not targeting ads based on the recording. The other thing is it would be totally illegal, right? Because we have WA Surveillance Devices Act, which says you can't record a secret conversation, right? So they haven't got your consent, so they can't record you. Secondly, the Federal Privacy Act makes it illegal to collect unfair collection information. And if we can recall, Facebook was actually fined $50 million for their Cambridge Analytica data misuse in the past by the Privacy Commissioner. So there are laws in place, and it would be a criminal offence if they were doing it. There's also ways for you to kind of check. So if you suspect when your microphone's on, your iPhone, for example, does have a little light on, but there's more sophisticated things you can do. That you can actually, and this maybe technical listeners can help me out here, but if data is being sent secretly, you can actually track data packets leaving from your phone. So if they were recording your audio, there would be a consistent stream of data coming unexpectedly, and it would be unexplained. So a lot of researchers, I believe, have looked into this, and they would be able to find it, right? Right. So then it's like, how do we get to this situation where it's we get into this situation because Facebook does collect a lot of information from you legally. So they obviously, you give them a lot of details already. They track off-platform behavior. So if you go into a store and stuff like that, they have data brokers that they buy information that collect a bunch of stuff from you. They collect information from all your network and your devices. They can see your IP address and they can match that up. They track how you behave on the platform, you interact with people. So all of this collective data they collect on you, and because there's so many people using this platform, if someone talks about a subject and then they see it advertised on them, it's very likely it will just be a coincidence just because of just the laws of numbers and the sophisticated data processing they have. So that's my view. I think that if someone's very technical that knows that they can probably, I think you would be able to catch them out if they were doing it.
All right. Nick Maruchak with us today. If you have a legal question, 1338 882, or you can text in 0487 999 882. Nick, a little story we had didn't completely finish last week. One of our listeners had called in, and an executor of a will was taking an extraordinary length of time, a long time, to process issues and to work through the content. What's your further comments to that?
Yeah, so I did email that listener a bit of tips, and I think this is something that we hear often on the show. So basically, the rule of thumb is that the court expects you to finalise the administration of an estate in 12 months. It's called the executor's year. So if it goes past 12 months without good reason, that will probably count as an unreasonable delay. So if you're going into the 18-month territory, that will probably be something that the court would look at misconduct unless there's a really good reason. And some of the consequences for that are there's actually something in the Administration Act which will allow a penalty, a 5% interest per year that can be paid to the beneficiary for that delay. So that's their interest, right? And that's the cost of missing out. And this can be actually passed on to the executor. So if you're entitled to $250,000, 5% interest over like a 2-year period is $25,000, so it does add up. If the executor is not, so executor has a duty to do things in a reasonable time, secure the estate, move in a sufficient pace. If they're not doing that, then some of the things you can do is one of the things is called a passing of accounts. So the passing of accounts is basically a process where the Supreme Court will call the executor in, and they will ask them to give all information about what they're doing, have a look at all the expenses and the receipts, and also come up with a plan, right? So if they haven't distributed the estate, then they have to come up with a plan on how they're going to finalise it. So that's one of the things that a beneficiary can demand the court do. And that's the first kind of material step, because once you're in front of the court and the executor gives this plan, then and the court's not happy with it, that could be grounds to remove them.
Okay.
Another option is you can actually directly file to remove the executor, but I think passing of the accounts is probably a good first step. And then the other case is if you think there's also another power in the Trustees Act where Section 94, where if any interested person wants to kind of review an executor's decision or require an explanation, they can actually apply to the court. So if executor's made a weird decision you're not quite sure about, you have this other angle where you can apply to the court and get them to provide an explanation. So there are steps that can be taken, and unfortunately there isn't like a regulatory authority that monitors except the Supreme Court.
Okay. All right, let's thank you, Nick. Let's go to the phones. G'day, Ben.
Hey guys,
Hey, mate.
I had a parcel thief stealing parcels, so I set up a camera and I filmed him, recording in the act, and then a few neighbours also chucked in some footage, and we figured out where he lived. So we let the police know, and they went and supposedly arrested him and confirmed his identity. But then they said they couldn't charge him because they couldn't find the stolen goods. So I just find that a bit odd.
So they know who it is, but they can't locate or identify the stolen goods. Ben, your phone's a bit noisy there. Is that what you said?
Oh, sorry, mate.
No worries.
They found his address. We got his address.
Yeah.
Footage of him walking from the house to his house with the goods.
Yeah.
But because a week later when they went to investigate, they couldn't find the stolen goods, they can't charge him. So it seems to be maybe a court problem.
What do you think, Nick?
So they might not hold up in court.
Yeah.
But we've had multiple reports. It just seems a bit odd because there's cameras everywhere. So really, if I do something wrong, as long as I haven't got the item in question on me, I can't be charged.
Yeah, so they have to prove beyond reasonable doubt, and in order to prove theft, they have to prove that the person has basically taken the item under the criminal code. So the police will have to make a decision that they have the discretion to prosecute, and they will prosecute if there is reasonable basis to get a conviction beyond reasonable doubt. So this is the discretion of the police and the prosecutors, and if they've made a decision that they don't think they can get a conviction, then it's probably not in the public interest to prosecute. Having said that, I think if you speak to some criminal lawyers out there, there's probably been some cases run where maybe they haven't found the item located, right? And there is other evidence, it's called circumstantial evidence, to show that the person stole the goods, right? So if I can take it back to the mushroom lady, right, we didn't see her put the mushrooms in the beef Wellington, but there was a lot of surrounding evidence where you could draw an inference that she did that. So the police could use this inference to draw the conclusion that the item was taken and what the item was. So it's really a call for them.
That it's too hard basket for them because the Tones West, he's got form. They just don't seem to care. As soon as we brought up that the rest of the neighbours are all a bit worried about him as well, because they're the only sort of Homes West connection houses in that suburb, and they just constantly cause trouble. But it just seems like they know about him and they just don't care because it's too hard.
Yeah, Ben, I hear what you're saying there, and I spent a bit of time with the Commissioner on a fortnightly basis and other coppers. I don't know if it's they don't care. I don't think it's a priority for them, which is slightly different, right? So they're pretty overwhelmed. They've got lots to do, and then if the chance of landing a prosecution are limited, it's not a priority. If the penalties are there and if they can enforce stuff, they will. It's a little bit like the issue of being able to shut down vaping shops, Ben, if I can draw a parallel. So
yeah,
I don't know if it's a not care, mate. It's just not a priority because they can't, because the deterrence and the enforcement aren't necessarily there.
Yeah, it just puts a bad taste in your mouth, like the social contract is we pay tax, we get looked after, we get services, we're just getting less and less of that. So, yeah, just another bad taste in your mouth.
Oh, yeah. What was in the parcel, Ben?
I'm not sure. I never got it.
Yeah, okay.
So, yeah, it was a gift. And then,
oh, no.
Yeah, now it's gone.
Okay.
And
But, it took them a week to go get it, to go check on him. We've done all the work for them. We've got the footage, we've got his name, we've got his address, we've got everything. But then if we go to his house, we're in trouble.
What should Nick? What should Ben do? We don't know what the value was, and Ben's not going to ring the gift giver to find out what it was.
Well,
what should he do?
The law says that you can be charged for basically taking anything that's capable of being stolen, right? So there's no minimum monetary value for the goods. So you could, he took the box. The box didn't belong to him. You can be charged for that, right? So it's not. My understanding is not an element to actually identify. It has to be the exact gift in the box. You can take that item that wasn't his. So theft can be for something small as well. So
the crime isn't that the gift; it's that he was on my property stealing on camera.
It
just seems remarkable that because I drive my car and I get a speed camera ticket. It's a photo of me doing a crime, yet I get charged with it.
Yeah, good point. Yeah, good point. That is only an infringement though. It's not a sort of a major crime. What should Ben do? Do you reckon, Nick?
Well, I think
you or Ben.
Well, I would. I don't know off the top of my head how you basically challenge this decision not to prosecute, but I would contact the police station and just ask the police officer, is there any avenue that I can go have this decision reviewed? I'm just not sure off the top of my head if there is, but I would ask for that. And if there isn't, then it's probably nothing you can do, and because this is. It's for the prosecutors to decide who to prosecute or not, and that's their power.
There you go, Ben. Thanks for having a chat to us today. That is very, very frustrating. 16 minutes to 11. If you'd like to contact us, you can. Troy, thanks for your SMS. We'll get to that after the break. This is Law Talk with Nick Maruchak from MKI Legal. You can call us 133 882. Nick Maruchak is with us from MKI Legal. If you'd like to phone in, I would certainly recommend that. Then we had a couple of text messages, Nick, but always better to talk to human beings because then you can interrogate the issue in a superior way. Troy says, what is the legality of an employer placing cameras inside work vehicles? And what is the... let's start with that one.
So this is an interesting question. They'll need your consent, right? So if they do it without your consent, then it's breaching the law, the Surveillance Devices Act, which we talk a lot about on the show. The way employers normally do it is they will get your consent through either the contract or they have a surveillance policy, right? So they have a surveillance policy in place and the contract says you agree to it. So basically, when it comes to policies and stuff like this, the policy have to be reasonable, right? So if you think that if there's no really good reason for the camera being in there, then you probably have a right to complain about it, and you should do. And also remember, when you complain about something to do with your employment, it's actually unlawful for the employer to retaliate against you. So if they fire you or disadvantage you, that's a breach of something called the General Protections Provisions under the Fair Work Act. So I would start with a complaint and have a discussion about whether it's reasonable, what are the employer's reasons for doing it, and could there be a less intrusive way of doing it? Because camera and visual recordings, there's probably a better option there. So,
thanks, Troy. Thanks to you, Nick. This one from Michael. Michael's in Herne Hill. I've got a query. Denied entry to a concert due to my tickets not wanting to scan at the venue. I bought tickets legitimately from Ticketek. Had to print out instead of using the mobile option. Was denied and treated badly by the staff. I'm going to try consumer protection since Ticketek aren't budging at the moment. If unsuccessful, do I have any legal standing to get my refund, says Michael in Herne Hill.
You do.
Complex.
Yeah, I mean, it's basically, look, if he bought a ticket validly, and as long as there was no good reason to deny him entry, right? So if he was intoxicated or he somehow was like breached conditions of entry, right? If he was acting as a civil person going in, so there was no good reason for them to deny entry, then he's got a claim for the refund because it's a breach of contract. He had a contract in place to enter the venue. It sounds like he did the right thing, and they denied him entry because I'm guessing maybe their machines or something wasn't working or a system failure. So that would mean, you would threaten just to take him to the magistrate's court. Again, we've been through this a lot. Minor case claims, anything under $10,000, you're pretty safe if you win or lose. This sounds like a good case. I've heard experiences of people going to consumer protection. Sometimes they take a long time. Remember, they're not a court. They don't have authority. All they can do is kind of bring people together for a mediation. If the other side doesn't want to participate, it's probably not going to be any good for you. Consumer protection does have laws to kind of fine people if they breach really serious criminal kind of laws. But the best bet is Form 4, download that from the Magistrates Court website, send it to Ticketek and say, hey, I'm going to file this. And sometimes the threat of it is good enough to get them to settle with you. Otherwise, you have to file it, and you go through a mediation process in the court, and hopefully that if they'll be paying lawyers a lot more to defend it than to refund your ticket.
Thanks, Michael. This one here from Jordan. What's the legality with someone filming with the main weights area of a gym? Party A is filming themselves and post a video of themselves, which includes Party B. Are they breaking any law? I would think generally, if you're going to publish something that's got somebody else in it, you need to get their permission, don't you?
No, I mean, look, you can record anything in a public place, right? So the restrictions of recording both...
Is a gym a public place?
Well, so public, like it is, because members of the public can come in. But what you can't do, right, these are the restrictions. So you can't record... The Surveillance Devices Act separates things to audio recording and visual recording, right? So the audio recording is the secret conversation, and the visual recording is a private activity. So you can't, those are the two things that are protected. So if someone is engaging in a private activity, and so, say for example in your backyard or something very, very, that there's an expectation that it's not meant to be public, then you can't record them, right? So in the gym, if you're just working out, it's probably not a private activity, right? But if you were having a very, like in the corner there, having a secret conversation, and it was very clear that this was private, there, and you recorded that conversation, maybe that would be an infringement.
Yeah.
So generally, no, that wouldn't be.
Yep. Thanks to you, Jordan. This one here from Daniel. Can you please ask Nick if the executor of the will has said he has grounds for delay? It's now been 3 years. Is there an end time frame when it must be sorted for the beneficiaries?
Well,
the estate's under probate.
Well, this 3 years sounds like it's unreasonably long. So Daniel should be taking steps now to write to the executor, tell them it's too late, they've been taking too long, and then threaten to pass accounts unless they do something quickly, and then do the process of applying to the Supreme Court to pass accounts, or the drastic step of having them removed and replaced with someone else. And on the face of it, 3 years is enough grounds to have the executor replaced and one of the beneficiaries to take over. There isn't actually an end date, right? It's on the beneficiary here to take the steps. So if you just do nothing, potentially nothing will happen. So here, Daniel's going to take some action.
Yeah. You'll take some action yourself, Daniel, by the sounds of things. 133 882. We could squeeze in another call with Nick if you would like to get hold of us. And I'm interested too. If you were caught up in the Nick and I discussed this a couple of weeks ago. If you were caught up in the town of Cambridge parking fiasco with Easy Park, have you got your money back? Let us know. Let us know right through the course of the show. 133 882. The town over there did back down, and they were going to retrospectively look at the fines they've been handing out for people using the Easy Park Act incorrectly. If that's you, let us know. 133 882 is the phone number today. Brendan says, I don't know if you've seen this story today, Nick, but Wayne Carey has outed himself as the bloke who was in the public toilet at the venue. It's a scandal that's been called Toilet Gate. And Brendan wants to know, is this a breach of privacy? So footage of Wayne Carey in a public toilet filmed by a member of the public and published, is that a breach of privacy?
Yep. Yeah. So I'm not fully across the story, but if someone is in a toilet, right, doing their business, then it would be illegal to record them because that's a private activity, right? So under the Surveillance Devices Act, that would be good grounds for that to be an infringement. So you can record someone you cannot record someone in a public place if they're performing a private activity, right? So that's the test here.
Yeah, okay. All right, well done. It is 5 to 11. Nick, thank you for this week. Look forward to catching up with you next week. And we're busy in the office, plenty to do.
Plenty to do, very busy.
Looking after the community, mankind, humankind.
Yep, well, doing all that and working a little bit on AI stuff as well to try and implement that into the legal practice, so yeah.
Sam's phoned in. G'day, Sam.
A question from Nick. Has anybody got the right to interfere with our right to speak in this country, the freedom of speech? When I go to council, I'm told I'm allowed 3 questions and we're only allowed to speak for 3 minutes. Surely that's depriving me of my right to speak.
Yeah, so great question. The long and the short of it is we don't have this right of freedom of speech in the same way America does. We have in our Constitution, we have a right of there's an implied right of political speech, right? So that can be so it sounds like Sam's kind of doing that. That's protected under the Constitution. But here, this is just the council setting regulations in place to kind of make it fair for everyone. So it's a question of whether they have interfered with that right, because there's other ways that Sam could do to get his message across, right? You can write to the council or do other things, but my initial gut reaction is probably appropriate if they set reasonable rules that apply to everyone here.
Yep, for public question time. Thanks, Sammy. Sounds like Sammy's still having his problems out there. It's Vic Parker, I think, Sam, isn't it, that you have problems with? It's 4 minutes to 11. Nick, thank you so much, mate. Have a good week, and I look forward to seeing you next week. And on behalf of myself and the team and our listeners, really appreciate when you do follow up with listeners. That's a nice thing to do. Thank you.
Appreciate it. Thanks, Bowie.
Cheers. Cheers. See ya.